Story is that allocations of loans and grants and redistributed monies altogether now are approximately 42% of all revenues or monies, not revenues, monies received by the central government are distributed back to the states. Roughly 42 or 41 rupees out of 100 goes back, which is about 5 to 7% more than it used to be all these 60 years. So this is a bedrock of parliamentary democracy, federalism, and federalism has been unintended, unplanned, undesigned, unprovided for in the Constitution by 6 reality-based factors which I just itemized. Before I now turn to the operational details or reality of parliamentary democracy, I want to just remind you how fortunate you are that you live in the Indian model. For all the criticism you do, for all the carping criticism we hear in the media, we still are fortunate. We are fortunate because I can sit in Central Hall and sit with anybody under the sun. The BJP president sits in the row behind me, a BJP friend sits on the left, a regional party chief sits, and we can talk anything under the sun. We are fortunate because Sonia Gandhi can pick up the phone and talk to Mr. Vajpayee, and Dr. Manmohan Singh can talk to Mr. Advani, and howsoever they might fight or seem to fight, there is a civility and a dignity of democratic discourse. Now, that's not something you should take for granted, because in a country just 1 hour flight away on the left, on your west, most of the time, if I come into power, the only thing I think of is how to put you into jail. And most of the time, there is no telephonic conversation. There is an uneasy truce if I have not put you in jail. That is true of almost 7 out of 8 or 6 out of 7 countries in our immediate neighborhood. And that is a facet of Indian democracy that is really, because parliamentary democracy is not about sections, articles, rules, nitty-gritty theories. It is about this spirit. This is an intangible spirit, but this is the real spirit of democracy. Parliament is an institution with multiple roles. I'll just take some water. Parliament is an institution with multiple roles. And obviously the first of those rules is to pass laws. The second of those roles is to be a fierce, free forum for fair and open discussion on non-legislative matters. In other words, in areas where you need not pass a law, but you can discuss anything. Thirdly, it is supposed to signify the assent of India's diverse and humongous population, an assent to make laws and to decide for them the rules by which they are going to be governed. And fourthly, Parliament is the grand inquest of the nation. That is really, I think, one of the most apposite descriptions of Parliament. As you say, Parliament is the temple of democracy. It is also the grand inquest of the nation. It's the largest commission of inquiry ever set up of the people, by the people, for the people. And really speaking, all these 4 roles are important. None can be said to be less important than the other. Over the years, several threats have emerged to parliamentary democracy. And since this is supposed to be a discussion on challenges to parliamentary democracy, let me come now to the threats and to possible panaceas, although there are no easy, quick fix solutions. The first is perhaps, it's not an Indian problem, it's a general problem in parliamentary democracy everywhere. And initially it was not considered to be a problem because it was a defining characteristic of parliamentary democracy. But over the years, it is now perceived as a bit of a problem. Not a major one, and it's common to all parliamentary democracies across the world, so it's not an Indian problem. But still, I personally believe it is becoming a problem, and that is that the theory of parliamentary democracy, which we follow, which England follows, which Australia follows, which New Zealand follows, which Canada follows, that theory, that system, that paradigm is one where laws must emanate from the executive branch of the government. Lawmaking, the idea, the structure, the form of law must come from the executive branch. But Parliament is a legislature by itself. But strange it may sound, a legislature has no power to create its own law and pass it. That's a very interesting contradiction and a paradox. So the executive, which is in the parliamentary system, in the British parliamentary system, which the Indians have adopted, the executive government, which is a part of the legislature, must introduce a bill for it to become law. But if all of us are parliamentarians in this House of Parliament, 750 of us, we cannot, two of you cannot initiate a bill and say that this is my bill, please consider it for passage. This in practice means that A, there is no real lawmaking power in the individual MP of any party. B, it means that the agenda of topic, substance, content, everything is set by the executive. So they decide what bill is to be passed. Of course, you can alter it, discuss it, etc. in Parliament, but the topic and the substance is decided by the executive. If you add to that a second problem, then the tyranny becomes complete, because these two problems go together. And that is the tyranny of the whip. The whip, as you know, is a letter which comes to all of us, which is either underlined once, or each line underlined twice, or each underlined 3 times. 3 times means a 3-line whip. A whip means that you are obliged to vote according to the party's stand on a particular bill. Now, the fact that the bill is brought by the government of the day, and secondly, it is coupled by a whip, means that the creativity, the independence, the new thought process, the new input of an individual member of Parliament becomes otiose and sterile. There is no scope for it, because a bill is presented, the party line is clear, obviously it's a government bill, so it has to be passed by the members of Parliament of the ruling party. If the opposition takes a different stand, equally, the opposition's mandate is clear, oppose the bill. Therefore, if the bill has some solid public interest for the nation, you as an opposition member of Parliament cannot get up and say, look, I think this is good for the country, I will vote for it, because your party says vote against it. Or similarly, I as a member of the ruling party cannot say, look, I think this is a bad law, it is going against. This is the problem. Now here is where the US system scores, because, and this needs a fundamental change of structure. The US system has the legislature as an independent organ in the true sense. That's the real meaning of separation of powers. The US legislature, consisting of Congress, which is known as the House of Representatives, and the Senate, any of those houses can initiate law. They can start a law, and that law then will be passed by that house. If the other house passes it, it becomes law, but it goes to the president, and if the president wants to stop it, he has only one power, a veto. Similarly, the president, the executive, can initiate a law. It becomes law, it goes to the house, but the house can veto it. That is Congress and Senate. So that's the balance of structure, but it allows a huge amount of creativity and individuality, which our MPs don't have. And this is an important point to remember, because we're discussing parliamentary democracy. This is parliamentary democracy, the essence of it, versus a US-type model, which you sometimes call presidential. But presidential has many other meanings. I'm on the law-making power. I have proposed a simple way of keeping the system parliamentary, which is what I believe in strongly, and yet not having this tyranny. The simple amendment would be that you should allow individual members of Parliament to raise bills themselves. By the way, we have a phenomenon known as a private member's bill. But a private member's bill is not what you think. It's a misleading term, because it's something which is kept for Friday afternoons. And a private member's bill, it never becomes law. It is only supposed to be a letting off of steam. So a private member can move a bill, and then he can debate in the House for 2 hours every Friday afternoon. But it never has a chance of becoming a law of the land. So a private member bill is not the answer. The answer has to be that a whip should be restricted only to those occasions where a no confidence motion is moved. You know, a lot of proposals are moved in Parliament. 99% of them are either for passing a law, ABC, or for raising a discussion. Only rarely, once in 6 months or 8 months, you have a no confidence motion moved. Now, when you move a no confidence motion, and you must call it a no confidence motion by name, then it is legitimate to expect the party in power to issue a whip to all its members that you must vote for the government. But a simple change in the law of one line can say that this whip will be restricted only to no confidence motions, which means that there is no threat to the government. When the government is under threat, the whip can be issued. But for all normal legislation, this whip will not apply. That means members of Parliament can speak according to their conscience, according to the merits of the bill. The most important part is the merits. because there is no black and there is no white in law. There's a lot of gray area, and there is some good and some bad. But parliamentary democracy of the ruling party and the opposition sometimes converts the debate of a constructive public interest national debate into a black and white binary win-lose situation, which it is not. And that is why I think this is important to consider. I'm sure it will not be considered for a long, long time, because purists think that this is sacrilege on the parliamentary system of democracy. Although I think this is a good via media to not go into the presidential form and yet reserve the whip for fickle and transient members who are trying to change the government, but not reserve it for other purposes. A third threat, of course, which you know well, but it's becoming a major real threat, is the threat of disruption, is the real disruption of Parliament. I have the figures. I will not, to save time, go into the figures. We are losing roughly 60% of parliamentary time to disruption. And I've got all the details. I mean, you know, when the Women's Reservation Bill came, for example, the law minister almost had to physically protect himself because it was snatched from his hand, about to be snatched from his hand. I've got the statistics, which I don't want to take time on. From the 50s, from disruption being about 18 to 20%, it is now exceeding 55 to 60%. Some sessions is 66%. Of course, we had one session which was washed out in November 2010. So this is, I think, a very, very sad situation. I'm not even going to the cost of 1 hour of parliamentary time. It's humongous. If you add the cost of each member of parliament's CTC, cost to the nation, plus all the attendant costs of running parliament, it is tragic. But most importantly, it means that we don't get our legislative business done. Now, let me not tell you the problem. You're familiar with the problem. And I could give you lots and lots of interesting details about the problem. Let's look at some solutions. It's not enough to say, oh, there is disruption. Why don't you suspend this member? And why don't you physically throw him out of the house? Those have been tried. But the problem is, this is a peculiar problem, because this is a problem where lawmakers are lawbreakers. The problem is that those you are trying to police are themselves the breakers of the law. And if you were to remove physically from the house those who got up and walked to the well of the house, then you will usually have an empty house from one side, and you'll have to conduct business, because this happens every day. So there is no real easy answer, because resolutions have been passed. Our rules don't permit anybody to come to the well of the house, which is a circular area in the center, and you can't come from there to here. But every day you find people coming in. So perhaps the only answer is to start with something which every MP knows can be done, but we collectively collude in not wanting to allow it to happen. And that is to firstly have an automatic suspension of allowances for that day, and to have, on persistent disruption, a suspension of some of the other perks. And I think for that we have to be very honest and candid in defining and admitting the total. You know, you'll be always told that a parliamentarian gets only a salary of 50,000 or 1 lakh. Now it's been increased to 1 lakh or 80,000 or something. But they don't tell you the CTC. The CTC is a different figure than the salary you get. CTC is the cost to the nation. And if you add to in that CTC the cost of the bungalow or the house you get, then of course it's very large. But if you don't even add that, it's pretty substantial. So if you start having automatic cuts in the CTC, it might make some significant difference. But this is something where, howsoever cruel, I think this will have to be practiced in the near future, because it is assuming alarming proportions. The other is this whole anti-defection law, where we need some change. The entire anti-defection law has been premised upon, as you know, the 10th schedule of the Indian Constitution, because these are the threats to parliamentary democracy. Today, getting elected on one seat and then defecting shortly thereafter has been considered to be a scourge. But ultimately, the anti-defection law works on the 10th schedule. The 10th schedule works on the speaker being made a judge. And now it is, I think, common knowledge that the 10th schedule in the speaker's jurisdiction has failed completely. Speakers have to be partisan. They have to ultimately vote as per their original party. And I think that needs to be changed very quickly to provide teeth to the anti-defection law. There are a whole host of very valuable suggestions to improve Parliament, which noble-intentioned bodies like the Parliamentary Research Service, by an excellent body of young people who have left lucrative jobs in America and in India, joined together to provide PRS and several other bodies, and you'll get them the literature. But real question is the will to implement. It is, of course, also important here, as I end, to touch upon the issue of human resource making up Parliament. A major issue is the human resources, which are the essence of parliamentary democracy. And the crux of the issue of human resources is the so-called tainted members of Parliament. Now, of course, let me straight away say that you have a very exaggerated projection of this issue. These figures that 50% are tainted and 25% have heinous crimes. This is completely wrong. A very small number of members of Parliament have criminal cases against them. The larger numbers you read in the press is because you cannot add every charge sheet or offence as an offence against an MP. More than 80 or 70% of them are those related to carrying processions or doing demonstrations or doing those kind of things, which are, I think, part of political activity. If you define tainted MPs as those accused or charge sheeted with crimes which carry a sentence of more than 3 to 5 years, then it would be not more than 10 to 15%, which is a very high and a distressing figure, I agree. But it's not as alarming as is made out in the press. I think this is something we have to address. The answer is very simple here. It requires only political will. And now, finally, we have reached a stage where specific models have been created. The simplest model is to change the law by one section in the Representation of People's Act to provide that a member of Parliament satisfying 3 conditions, or rather not a member of Parliament, an individual who aspires to be a member of Parliament or a sitting member of Parliament who wants to continue, shall not be qualified or eligible to do so if he satisfies 3 conditions cumulatively. One, that he is charged, or better still, you must put, if the charges have been framed by a court of law against him for offences involving a punishment, maximum punishment of 5 or more years. And almost all the major ones will come under that. But cumulatively, that's not enough. The allegation must have been made at least 6 months before the election for which he wants to file his nomination paper. Because it's very common that because I want to disqualify you, I come up with a fresh charge 2 months before the election. So that also is a